I am Jennifer Steinberg. I'm one of the attorneys at the Dale Law Firm. I've been with the firm for going on 18 years, which is kind of shocking to me, but and it's been a great ride. And I do currently I'm handling most of the conservatorship cases on behalf of the firm. So made sense for me to do the presentation tonight since I'm the attorney that those of you who end up working with us for conservatorship purposes will be working with. Steve Dale, as many of you know, has been working in the field of disability law and specifically focusing on services for families with disabled family members for a number of years and started the firm with that particular focus. As I mentioned, I joined the firm about 18 years ago. I'd known Steve for a number of years before that, back when we were both young lawyers, and he was volunteering and working with a disability rights group in Berkeley that I was also involved with. And we kind of came back together about 18 years ago and started working together in this practice. We've recently increased the size of our firm, so we do have a couple of new people. Diana Quigley, who some of you may be familiar with if you were at the previous webinar that we did recently. She's joined our firm and is working largely on our estate planning and third-party special needs planning part of our practice. She comes with a great background in estate planning as well as tax law, so she's being a really great addition to the firm. And then we also have another attorney, Beth Hodis, who's joined us and is working more on a lot of our court cases that have special needs trusts as part of court settlements or other sorts of court actions. So we're growing and we're excited about the new opportunities that's opening up for us. And we hope that you see us around and continue to join us for our various educational webinars and sessions. So without further ado, I've given you a little background on the firm. I also just let you know that I am a sibling of an adult with intellectual disability. My sister Susan, who you sometimes will hear me refer to, is an individual with cerebral palsy as well as a number of health complications, and she lives in a supported living arrangement in Emeryville. So I often will refer to her and use her as my example as I'm going to go through some of the materials that we're going to talk about tonight. So jumping right in, hopefully you all know that you're here for the legal decision-making webinar for persons with intellectual disabilities. And we're going to be focusing primarily on limited conservatorships, but I'm also going to talk about some of the other options, as well as speak a little bit on supported decision making, which is kind of a newer concept in California and has just rolled out within the last 3 to 4 years. So we're going to kind of go over that. Before I get started into the various options, just want to point out that age 18 is really kind of the critical age for a lot of individuals. And that's when we see them kind of entering our world, the legal world, because as a person in California turns 18, they become a legal adult. And all of the decision-making authority and power that has previously been vested in their parents or in their guardians is now terminated, and at 18 there is a presumption that a legal adult can make all of their own legal decisions, and there is not a mechanism for parental decision making to continue short of a conservatorship or some of the other options that I'm going to speak about. It's important to keep in mind that this is regardless of the circumstances of the individual. So just because someone may have a significant intellectual disability where their decision-making deficits are quite obvious, that alone is still not going to authorize an individual to continue to be involved in the decision-making process for that person. As I noted, all persons over the age of 18 under California law are presumed to have capacity, and this presumption carries forward in all aspects of life, including their personal decisions, medical decisions, as well as all financial decisions. It's frequent that it's really the medical decision-making authority that kind of drives a lot of people to seek a conservatorship. But it can also be very critical that there is legal decision-making authority in place for other aspects of the individual's life as well. And so I'll talk a little bit about the different ways that we accomplish that. A few things to think about is that, if a person with an intellectual disability cannot independently make or communicate informed decisions, then there really does need to be some sort of mechanism put in place to allow for decisions to be made on behalf of the individual. And this idea of intellectual capacity or cognitive capacity is really a two-prong consideration. It's not just whether or not the person has the ability to understand and make a decision, but there's also this communication component. And sometimes that can easily be overlooked, but that's a component that also can sometimes be facilitated. But it is an important aspect and something to keep in mind. Now, I've mentioned that there are a number of options for decision making in California, and I'm going to go through each of them kind of in turn. And of course, we're going to spend more time talking about supported decision making and legal conservatorship. But the others that I want to mention, and they often can be utilized for the individuals we work with. The first is a power of attorney. Now, many of you may be familiar with powers of attorney already. Many individuals have them. I have one. My husband has one. Most of our estate planning clients have them in place, so you may well be familiar with them. It's basically a document that allows for an individual to grant someone else authority to make decisions for them. Similarly, there's an advanced healthcare directive, which is a document where an agent for medical decisions can be designated. And this is what we call it in California as an advanced healthcare directive, but we often hear these referred to by healthcare powers of attorney, living wills. There's lots of different terms that basically encompass the same sort of thing, which is a document where an individual is designated for purposes of making healthcare decisions. And then, as I noted, we've got supported decision making and limited conservatorships. And then another option that people sometimes forget to consider is it is possible in some circumstances to do nothing at all. And we're going to talk about what that might look like as well. First, I want to talk about powers of attorney. A power of attorney is, as I mentioned, it's a legal document where an individual can voluntarily designate someone to make decisions on their behalf. In the most common scenarios, it's usually husbands and wives or spouses that are doing this, and they're granting each other authority to make decisions. Sometimes it might be a parent designating a child. We see this frequently with individuals as they start to age and they need more assistance with day-to-day activities. They may use a power of attorney for that purpose. But the one thing to keep in mind that is important with the power of attorney is that the person who's granting the authority to the third-party individual must understand what it is that they're granting. There must be a certain level, at least, of capacity so that the individual understands that what they're executing is giving power to somebody else to make their decisions for them. It's also important to keep in mind that a power of attorney does not take away the individual's ability to make decisions for themselves. So again, using myself as an example, while I have a power of attorney that's named my husband as my agent, I, of course, can still make all of my own legal decisions, and the power of attorney does not in any way limit my ability to make decisions. It's just granting authority to someone else. It's like a shared ability. Powers of attorney are also very customizable. They can be used very broadly, covering almost all aspects of an individual's life. And in fact, most usually are. If you have what's in California, we have what's called a statutory power of attorney, and that grants a very broad blanket authority to take action in most aspects of someone's life. or it can be very specific. It could be for a specific purpose. It could be for a single transaction. It could just cover certain aspects. So it could only be financial and not personal, or vice versa. So again, very customizable and very powerful documents. As I noted, a durable power of attorney does not prevent the principal from making a decision. So when we're working with individuals with intellectual disabilities, you do need to keep that in mind. What that means on a practical level is that if you are designated as an agent for a family member under a power of attorney, and there's a decision that needs to be made, and that individual wants to do one thing and you think they should do something different, their decision is always going to be able to trump yours, because we are not taking their individual decision making away, and they are always going to be the primary individual. So if there's concerns about an individual not making informed decisions or making inappropriate decisions for themselves, then a power of attorney may not be the right answer in those cases. A durable power of attorney can also be revoked by the principal, which again kind of goes to the same concept that they're always in control. The principal, the person who's granted the authority, can revoke that authority and take it away at any point and at any time, and for any reason or no reason at all. So again, it's ultimately always controlled by the individual who's executed the power of attorney. An advantage of a power of attorney is that they're very commonly used and they're readily accepted within the community. Most individuals that you will be using the power of attorney with will immediately recognize what it is and accept it, and not give you any real pushback with regards to accepting it. It's even so common, and most people don't really understand all the ins and outs, that frequently, even when an individual with an intellectual disability that shouldn't effectively have been able to execute a power of attorney does so, people will readily accept it. And so sometimes it can be problematic in that regard, in that there is some potential abuse that could be used with these documents. But again, they do work well for the right individuals and in the right circumstances. Another advantage, before I move on, another advantage is that these documents do not require any court involvement. They are usually prepared. They don't have to be prepared by an attorney. They can be prepared by an individual, and they can just be signed and notarized. So they're easy to effectuate. They're easy and quick to put in place, and they're fairly inexpensive. So again, other reasons why, if it's a good method of sharing decision making with your family member, it might be something to consider. An advanced health directive is similar to a power of attorney in that it is, again, a situation where an individual voluntarily is authorizing another person to make decisions and assist them with healthcare decisions. It, like a power of attorney, is a revocable document. So while the individual can voluntarily share power with the agent, they similarly can take back that power and they can revoke the advanced healthcare directive at any time. So again, it's got those same considerations and factors involved. In addition to allowing someone to appoint an agent for decision-making purposes, an advanced healthcare directive also allows the individual and enables the individual to let their wishes be known with regards to certain types of healthcare, particularly end-of-life care, whether they want life-sustaining treatment, and as it says there on the slide, anatomical gifts or organ donations, and some other healthcare sorts of issues are called out in the document and can be fleshed out. It again can be very customizable. You'll see on the screen here, there is a copy of the California Medical Association's kind of booklet that they distribute widely. Many doctors' offices use these, and you'll see them frequently. Our firm uses them And so they're widely recognizable. But if you were to look through the form, you would see that they've got some sort of general responses for like end of life care options, but then they also provide you the opportunity to be very specific and add additional comments and information as you choose. So again, a very customizable document. They are also widely used. If you happen to be a Kaiser member, and I'm sure some of you may be, Kaiser does have their own form, and they do ask you to use their form because, again, all of their doctors and medical professionals within their system are familiar with it. It would be scanned into your electronic medical records there at Kaiser and would be available to anyone who you would be working with. So again, it's a helpful tool, but I do recommend that you use their form if you're going to go in that direction. It's readily available through their website. If you just were to Google Kaiser Permanente Advanced Healthcare Directive, it'll take you right to the form. So it's very easy to use. I've already mentioned that it can be revoked at any time by the principal, and so again is a a way of sharing decision-making authority. But keep in mind that in order for it to be effective, the person who's executed it does have to have an understanding of the nature of the document that they've signed, what it is that they're agreeing to, and the consequences of that. So if there is a concern that the person you're working with doesn't have that level of capacity, as we refer to it, then you may not want to use this document. It could cause problems and it may not be effective for you. Some things that an agent is not allowed to do under an advanced healthcare directive, there are some restrictions and some limitations. They're listed here. You'll see that these tend to be fairly extreme types of treatments and somewhat controversial. Several have to do with psychiatric treatment, and then reproductive decisions and assisted suicide are on those lists. So probably not shocking that these are the types of things that an agent can't authorize. They can only be authorized by the individual personally if they have capacity, or by a medical professional, not by an agent under under an advanced healthcare directive. Okay. I mentioned earlier that one of the other options that a person or that a family may have when they've got a family member with an intellectual disability is really to do nothing when that person turns 18. And we see this from time to time where families haven't actually pursued medical or other types of decision-making authority for their family member, and sometimes that works out just fine. Other times there could be things that come up primarily again in the medical field. And so it's good for you to know that if this is something that you're thinking of doing, that there is a provision under the Lanterman Act for the regional center to be able to authorize medical treatment for a regional center client who has been determined by a medical professional to not have capacity to give informed consent. And so we have had clients that have chosen, again, the do nothing route, where this has been utilized for them to still be able to be somewhat indirectly involved in decision making and being able to still manage healthcare without having the formalities of either advanced directive if the person has capacity or going through a conservatorship if they don't. The regional center director is the person who's authorized to make the decisions, but frequently what we've seen is that they then delegate that to another staff person, usually a medical professional that is on the staff of the regional center, to be the decision maker. And it's always been my experience when I've seen this utilized that the regional center will work closely with the family or the other advocates that might be involved in that person's life, and will certainly take their wishes and their consideration, their concerns into consideration, and work as a team collaboratively. However, I will caution that ultimately the decision is going to be made by the regional center employee, and they could make a decision that would be contrary to the family's wishes. And so that's something to think about. Again, usually we would only see that happen in some sort of a controversial situation that involved maybe one of those other sorts of treatments that I mentioned a moment ago, psychiatric treatment or reproductive health decisions and things like that. Amy, before I get on to the next topic, this might be a good chance to check in with you. Do we have any questions or comments so far?
We're good.
We're good? Okay. Then I'm going to move on and get more into the meat of what we're really going to be focusing on tonight for the rest of the discussion, which is both supported decision making and conservatorship. So starting out with supported decision making. As I mentioned, this is a fairly new concept in the law, at least here in California. I know some states have had some form of supported decision making formally in place for about a decade or more. Texas was actually one of the leaders in this area, funnily enough. And they've had their statutes in place for quite a while, but it's only been within the last 3 or 4 years that we've really seen this formalized in California. The concept is that this is a arrangement where a person with a disability can gather and select a group of people who they choose and who they trust to assist them in exercising their decision-making ability. This is not a situation where they're sharing decision-making authority with third parties. They retain the right to make the decisions for themselves, but they have a formal mechanism that is being put in place where other individuals of their choosing can assist them in making those decisions. And how that assistance materializes can vary very much from person to person. A lot of times it's just working with them, sitting down with them, and helping them synthesize information that they've received and being able to kind of go through that so that they can make informed decisions about the important things going on in their lives. But it's a very, as the term supported decision making implies, it's a very person-centered form of decision making and moving forward. The person with a disability and their supporters that they have chosen enter into a formal contract. It's called a supported decision making agreement. No shock there on the name. And that agreement has certain elements that have to be included within it for it to qualify under the statutes that California has put in place. Generally, the agreement is going to list the areas that the person has requested support regarding. So, and again, this kind of matches similarly some of the areas that we'll talk about in conservatorship. It includes decisions about the person's residential needs and where they're going to live and with whom they are going to live. It can include employment-related decisions, benefit-related decisions, community support decisions, all of the things that we think about and the areas that are going to come up from day to day, in someone's day-to-day living situation. The law also requires that the supporters be what's called eligible. It's not a high bar. It just means that the person has to be over the age of 18 to be a supporter, and they can't have any person-based criminal activities in their background, and there's some other sorts of requirements along those lines. But for the most part, most people over the age of 18 would probably qualify to be a supporter. And they have to sign a statement that they will support and implement the direction and the preferences of the person with a disability. Again, always keeping at the forefront that the person with a disability is still the ultimate decision maker. I noted a second ago some of the areas, these are the ones that are actually called out in the statute, but it's not an exclusive list. Anything else that you could think of or that the person requests support regarding can be included. But these are some of the common areas of decision making that will be included in the agreement. There's medical and psychological treatment, again, much like a conservatorship, financial transactions and arrangements, education and services, living arrangements, social relationships, employment, all of the things I mentioned earlier. And if you think about it, this is a fairly broad list covering most aspects of any individual's day-to-day life. The law also requires that the agreement be reviewed and updated on a fairly regular basis. The law requires that that be done at least every 2 years, but the agreement itself can call for that review to happen more frequently, or it can happen at the request of either the supporters or the individual with the disability. So again, we want to keep it a live, living document that is flexible and able to adapt to changes in the individual's life. So frequent updates are certainly preferred. The agreement can also be terminated if it's no longer appropriate or valid, viable. And that could be, the termination can be directed by the person with a disability, obviously, or all of the supporters. Now note it says all of the supporters, so no one individual can terminate it other than the person with a disability, or it can't be done by just a majority of the supporters even. It does require that it be a unanimous decision of the supporters. The terms of the agreement can also impose a termination date. And this is often included when we have agreements that are all being set up for a very specific purpose, maybe a single type of transaction. And in that case, we would have terms in the agreement itself that calls for its termination. And then, unfortunately, the last one is kind of an obvious. If the individual with a disability passes away, then the supported decision-making agreement or arrangement terminates at that moment in time as well. The nice thing is the fact that we now have these agreements in statute is that it means that third parties, those individuals and entities that we all have to work with within our regular and recurring activities of life, must respect and agree to implement the decisions that are made through the supported decision-making process. Prior to California formalizing these, there were people that still put these arrangements together, but oftentimes they weren't terribly effective because people in the community wouldn't necessarily recognize it or participate in the process. So now we have a statute that we can rely on that says that they do have to be recognized, and that a person can't, or an entity can't, disregard the decisions just because they either don't agree with or understand the process. The person with a disability is entitled to have one or more supporters participate in meetings. So this is important when the person with a disability is dealing with medical professionals or legal counsel. If they've coming to meet with me, they are entitled to have their supporter present in the meetings, and those supporters cannot be excluded. The only time a supporter can be excluded from a meeting that would otherwise be potentially confidential is if the supporter is either asked to not participate by the individual with a disability. That is one option. Or the other is if the third party has a reasonable belief that the supporter is exerting some sort of fraud, coercion, or abuse. Now, how that's to be assessed and ascertained obviously could lead to some controversy, but I've actually so far not seen there be any problems in that regard. So anyway, that is the purpose of kind of formalizing this supported decision-making agreements in statute, is so that we do have that ability to really enforce the decisions that are being made. Okay. Any questions on supported decision-making?
Just one.
Okay.
Are these documents actually filed with the courts?
No. So a supported decision-making arrangement or agreement is a private contractual agreement. It's not filed actually with anyone. It does not have to be filed anywhere or with anyone to be effective. However, saying that, what we recommend to a client, if we're working with them on this, I would be suggesting that they do make sure that copies are available, again, depending on what the area of decision making that's covered by the agreement is concerned with. But for instance, if it involves medical, I would want to make sure that a copy of the agreement itself is provided to medical providers, whether that be your personal doctor or, again, in the case of Kaiser, have them put it into the medical records. Um, if you're dealing with regional center, IPP issues, IEP issues, if the individual is still in school between ages 18 and 22, you could have one of these agreements in place. Make sure that, regional center case manager is aware of it, has it in the file at regional center. Similarly, the folks at the school district should have that available to them. And those are kind of the big ones that we come up with. There may be other circumstances or other reasons that people would share them with outside people. But again, no requirement that they be legally filed anywhere. They don't have to be, somehow blessed by the court. Again, it's a private contractual relationship that the person with a disability is entering into with their supporters. Again, in that way, it's much like a power of attorney and an advance directive, in that neither of those documents formally are filed anywhere either. They're just documents that are executed and then produced and shown to individuals as needed. So I hope that answered the question. Okay, conservatorships. So conservatorships are kind of a little bit of a different animal for a number of different reasons. The three options that I've talked about, or the four options that I've talked about before: powers of attorney, advanced healthcare directives, and supported decision making, all require that the individual with a disability have at least a certain level of understanding and ability to make decisions. A conservatorship is really intended to be put in place on behalf of an individual whose disability is significant enough that they really can't participate in the decision-making process for themselves. And so again, it does require an assessment of capacity, and we'll talk about how that comes about in a moment or two. A conservatorship is a judicial proceeding, and that's another way that it's different from the three alternatives that I've mentioned previously. It does require that there be court involvement, and that it's a fairly stringent legal proceeding that you're undertaking when you're petitioning or seeking a conservatorship. It can be used not just for people with intellectual disabilities. It's also commonly used for people who are older and are starting to lose capacity because of issues regarding aging. And also, it is used widely for individuals who maybe have behavioral health or mental health disabilities that affect their ability to make decisions in their own best interest. Incapacity, again, or lack of capacity, as we sometimes refer to it, is necessary to establish a conservatorship. A court will not conserve an individual if they determine that the person has capacity. And how that determination is made is a quite rigorous process. But ultimately, in the law, it says that it must be shown that due to a disability, the person is unable to make and communicate, again, there's that communicate component, decisions, or to understand and appreciate the consequences of the decisions that they're articulating. So it's really, it's not an easy definition to necessarily wrap your head around, but it does try as best it can to ensure that we're looking at all aspects of decision making and really trying to assess the individual based on a number of factors. The process that's used, before I move on to the next slide, I'll just tell you the process that's used by the court is that a doctor, a medical professional, a psychiatrist, or a licensed psychologist will have to complete what's called a capacity declaration. It's a form that the court uses where that individual is to assess the various functional abilities of the person at issue. And they have to go through with some particularity and give the court information as to their experience with that individual and how they assess various aspects of functioning on behalf of that person. And I'll be honest, many doctors don't like completing the form. It is fairly rigorous and it's actually been made more so over the last few years. It does go through a variety of aspects of life and asks them to comment on these things. And so it's a bit daunting for some doctors, but it's a necessary part of the process. So if you were to work with our firm or a firm like ours that's experienced in this area, we spend a lot of time working with you and trying to get this document put together. And usually we ask you to work closely with your doctor to try and get it accomplished because sometimes it can take a bit of time. So just be prepared. And again, if you are a Kaiser member, they have an internal process within Kaiser that this has to go through. And it can take several weeks, sometimes months to get it completed. So it's one of the very first things we do is to start working on this so that we can get it done timely and it doesn't delay the proceedings once we get things filed with the court. Okay, conservatorships, you've heard me mention that they can cover various different types of people with disabilities, and they also can cover different aspects of life. So generally in California, there's two types of conservatorships. There's what we call conservatorship of the person and conservatorship of the estate. The two types have to do with the types of decisions that the conservatorship covers. Conservatorship of the person, these are decisions that have to do with personal autonomy. It's the things like who are we going to have relationships with? Who are we going to live with? What is our residential circumstance going to look like? What sorts of community services are we going to be participating in? Medical decision making. It's all of the decisions that kind of go to our person, to our individual needs. Conservatorship of the estate, on the other hand, is financial. It's dealing with the conservatee's property, assets, finances, income, all of those sorts of things. So there is the two. Now you can petition for one or the other or both. I will caution you that if there is not an actual estate, in other words, if the person that is going to be conserved does not have financial assets, the courts are very resistant to granting a conservatorship of the estate. There really does need to be a purpose for having that power. And they don't consider, oh, I'm just trying to be proactive in case some money comes in down the road. They're not going to grant a request for a conservatorship of the estate usually in those circumstances. So if the family member that you would be seeking to have a conservatorship for currently does not have any real assets, then a conservatorship of the estate is probably not something that you're going to be encouraged to seek. And in fact, we would tell you not to seek it unless you really need it. There's one caveat that I'll speak to, which is many of our clients are receiving public assistance benefits. So they might either be on SSI or they might be receiving regular Social Security. And in those cases, if they aren't able to manage their own finances, they usually will have a representative payee appointed by the Social Security Administration. And that person has the legal authority under those laws to administer and manage those assets. So a conservatorship of the estate is not required and won't be granted if the person's only assets and income are coming through those needs-based programs. Amy, I see you popped up. You're muted, Amy.
Sorry. We need to define what LPS is.
Okay, I'm going to get there. Haven't gotten there yet.
Well, someone's jumping ahead. Sorry about that.
You guys are jumping ahead on me. Okay, so hopefully with that, you understand the difference between the person and the state. Now, if you look down the other side where we've got LPS listed, you'll see there's a general conservatorship, a limited conservatorship, and then this LPS conservatorship. So let me tell you what the differences are. Limited conservatorship is the one that we're going to be talking about for the rest of my conversation. That's the type of conservatorship that is used when the individual being conserved is a person with an intellectual disability. If, however, the person is either just elderly and is starting to have cognitive decline because of age, or if the person has a mental health disability, psychiatric disability, then they're going to be looking for a general conservatorship. The limited conservatorship statutes are very narrowly focused for people with cognitive and intellectual disabilities. Basically, someone who is a regional center client. If you're a regional center client, you're going to qualify for a limited conservatorship under the laws in California. Now, an LPS conservatorship for psychiatric care, since we were asked about that, I will certainly let you know what it is. This is the type of conservatorship that is used when a person with a mental health or behavioral health disability requires extensive treatment and where they've been found to be gravely disabled because of their psychiatric disability. It's used primarily for when someone needs to go into a locked psychiatric facility or needs to be under those super restrictive sorts of treatment options that I mentioned earlier, like psychotropic medications, convulsive therapy, things like that can only be done through an LPS conservatorship. The other thing to know about an LPS conservatorship is that it can only be initiated by a county employee. Usually it's someone within the Department of Mental Health. Each county kind of handles it a little differently, but it cannot be initiated by a family member or an independent third party on behalf of the person with the disability. It can only be done by a county official. Usually these LPS conservatorships are a result of a 5150 where someone has been taken under a psychiatric hold for a limited period of time. And at the end of that limited period of intensive psychiatric treatment, it's determined that they need that to be extended. That has to be done through an LPS conservatorship proceeding. So that's the differences between the different types. Okay. As we've already discussed, limited conservatorship is intended for persons that are identified. The legal definition still refers to a developmental disability, although you'll hear me probably use intellectual disability more frequently. In order to qualify, the disability has to have originated before the age of 18. It needs to be expected to continue indefinitely, so not a temporary sort of situation. And it includes, and these things are specifically called out in the law, it includes intellectual disability, cerebral palsy, epilepsy, autism, spectrum disorder, or any condition found to be closely related to intellectual disability. Again, it doesn't exactly mirror the requirements for regional center qualification, but as I noted earlier, if you are a client of the regional center, you are almost always going to meet this definition under the limited conservatorship statutes. I believe the only exception might be the age. I can't remember, but I think I want to say under the Lanham Act, the disability has to manifest before age 21 instead of 18. I could be wrong there, so don't quote me on that. But it's, again, a very close definition. A conservator of the person, and again, I'm just going to be talking about person powers for the rest of my discussion because that's the ones that we most commonly are seeking in our practice. A limited conservatorship allows the applicant, the person applying to be the conservator, to pick and choose the areas of legal authority that they wish to be granted. There are seven areas, and I've listed them here for you. Again, it's the ability to select and control residents, so where and with whom the individual will live. Access to confidential information and records. So this is kind of a privacy release disclosure. It allows for the conservator to have access to the individual's medical records, regional center records, social security records, all those sorts of things that might otherwise be shielded by confidentiality law. It allows the conservator to give consent or to withhold consent for marriage. It also allows the conservator to exercise the person's contract power, the ability to enter into a valid contract. You'll note that that's the one quasi-financial power that's granted here. Medical decision making is always a big one for families that we're working with. The ability to control social activities and intimate relationships. So this is kind of more the social recreational types of decisions that one might make. And then the last one is the power to select and control education or community-based services. So this is the power that would allow the conservator to continue to be involved in the IEP process and directing education if the individual is still of school age, or more commonly to be involved in the IPP process with regional center and directing their community-based services and supports going forward after age 22. So those are the areas of authority. It's super common for the clients we work with to ask for all 7 of these. It's generally accepted that the court usually they usually will grant at least 5 of the 7 without too much discussion or comment. There are 2 that the court will sometimes withhold. That is the consent for marriage and the ability to control social activities and intimate relationships. You will also, what we're going to talk later about the regional center's role in the conservatorship process, but they are also going to be solicited by the court for their position with regards to these powers. And those are the 2 powers that frequently Regional Center of the East Bay will recommend that the court reject. And the thinking there is just that those are such intimate, personal relationship powers that it really shouldn't be given to a third party to make those decisions, except in the most extreme cases. So, but generally, the other 5 areas of authority are not generally too controversial. Again, assuming that we've already cleared that capacity hurdle, the court generally will agree to those. There are again going to be some limitations on what a conservator can or can't do under a conservatorship, and you'll see that these kind of mirror the ones, that we mentioned earlier with regards to the Advanced Healthcare Directive. So a limitation would be that the conservator cannot commit the individual to a locked psychiatric facility. Again, that can only be done under an LPS conservatorship by the county. You cannot authorize treatment with experimental drugs. So, drug trials or that sort of thing can be done by the conservator. No electroshock treatment and no sterilization or reproductive sorts of interventions. Excuse me. It is possible for the conservator to seek a further court order if any of these 4 things comes into play and becomes necessary. We occasionally will have families that will ask us about the reproductive choice decisions and want to be able to implement those. I would just caution, if that's something that's of concern to you, I would caution that you think twice before going down that road. The courts are very, very resistant to approving a sterilization or other sorts of more permanent sorts of reproductive interventions. And it'd be extremely expensive to try and secure that order. And I honestly think that the odds of being successful are quite low. So just with that caution. Okay, I often get asked about conservators. Who are appropriate conservators? How many conservators can we have? Those sorts of questions. There's really no limit on who can be a conservator. It's most frequently going to be family members, and family members are actually given preference under the California statutes. But it doesn't have to be family members. It could also be other individuals who are personally familiar with and have a relationship with the conservatee. It could be a professional of some type. Frequently, we see professional fiduciaries step in and act as conservators, or care managers can be appointed. These are utilized more frequently when maybe the individual doesn't have close family that's available, doesn't have a circle of personal relationships or friends that can be pulled from. And then in those cases, professionals can be utilized. In cases where there are not the resources to pay for a professional, then the options are usually going to be either the regional center or the State Department of Developmental Services, both of whom on occasion will step in and serve as a conservator, although they really prefer not to, and they will only do it usually as a last resort if there's no other option and if it's absolutely necessary. And then the final would be the public guardian. Now, each county has an office of the public guardian, the mission of which is to provide the sorts of supports that individuals need where they have a lack of capacity, and they will step in and they will manage an individual's both personal and financial decision making for them. But again, it's always usually the case of last resort. An individual has to be referred to the public guardian by the court, and the courts, because the public guardian's office, quite honestly, are not well funded and often overwhelmed. The courts are very resistant to referring to the public guardian unless, of course, they just have no other option and a conservator is necessary. So those last two options are not used frequently, but they are available if there's no other if there's no one else available and we need a conservator to be put in place. As to the number of conservators, you can have multiple conservators, and in fact, it's very common that we will have conservators more than one appointed, and we usually recommend it. You can have as many as is practical. There's no magic number. You could have 3 or 4 or 10 if it's practical. I think 10 is probably not practical, but some families that are very close do have more than just mom and dad. They might have siblings or cousins or aunts and uncles, or other people that might be involved. What's important to know is that when individuals are appointed as co-conservators, they share conservatorship authority and responsibility. There is no hierarchy of conservators. So it's not the situation where mom and dad and brother and sister are all appointed and mom and dad make all the decisions and brother and sister just get to sit in the background and do nothing. That's not the way the law intends it to work. It does say that all of the co-conservators share authority and have equal authority to be involved and participate in the decision-making process. Where you have two conservators in place, they must make decisions by consensus. What that means is that they both have to agree. If you've got two conservators and they can't agree on a particular action, then the action does not occur. So keep that in mind. If you've got more than two, then it's a majority rule situation. So it's, again, as I mentioned, frequent for us to petition to have the parents appointed along with one or two or more siblings. It provides for a nice transition so that as mom and dad get older and start to age and not be able to be as involved, that the siblings can kind of naturally start to move into the director's chair, for lack of a better term. And it does certainly provide for that, but you do need to make sure that those siblings are involved from the get-go and that you're doing things the way the law intends. Now, that's the legal perspective. What I will tell you from a practical perspective is that usually when you are out in the world and you are working on behalf of the person with a disability, um, you're not going to need to have everybody in the room making the decision at that moment in time. As I indicated earlier, my sister has significant disabilities with significant health complications. I am one of her conservators along with my father. My father is himself quite elderly at this point. And so I'm frankly the one who is taking her to her doctor's appointments and monitoring her health situation and dealing with medical providers and the like. And, my father certainly doesn't need to go to each appointment with me and be involved. He doesn't have to sign off on every time I, consent to her changing her meds or, whatever the situation may be. So on a practical level, usually conservators have a certain amount of ability to work independently. But under the legal framework, decisions are supposed to be made by the group as a whole. As I indicated, having multiple conservators is certainly allows for a smoother transition, and it prevents there from being an inadvertent lapse in the conservatorship if someone unexpectedly passes away or becomes incapacitated. So we do usually recommend it. There's actually another practical side to having co-conservators appointed at this initial point in time. Even if siblings might be younger and not as involved as they ultimately might need to be later. If you don't add them now, and we have to add them later, either in a time of crisis, which is never good, or just because you're kind of planning and now you're getting to a point where you think you need to add, brother or sister, it does require that you then go back to court, file yet another petition with the court to have them added. It's not as onerous as this initial process in that we've already established that the person is disabled and needs the conservatorship and things like that. But it is still a fairly lengthy legal process that's going to incur legal fees. So again, just another reason to think about having kind of those that next level of individuals involved and have them join as co-conservators right up front. Looks like Kristen Harvey's raised her hand. Amy, you want to see if she's got a question?
Okay, I'm gonna allow Kristen to talk.
Okay, there we go. Kristen, what's on your mind?
I'm sorry, I was trying to ask in the chat. I was just wondering how old the child can be to join on the conservatorship.
Good question.
We have a younger sibling. I don't know how old the requirements are.
Yeah. So to be appointed as a conservator, unfortunately, the person has to be 18 because they do have to themselves be a legal adult and be able to make decisions. So, so a younger sibling, unfortunately, couldn't be put on initially if you're doing the conservatorship at the conservatee's 18th birthday. If their younger sibling wouldn't qualify yet. Older siblings certainly could be added at that point in time. So to qualify as a conservator, just generally what you need to know is it does have to be a person over the age of 18. They are going to be subjected to a background check. So, usually someone, not that I would suspect that of anyone in this group, but if we have people with felony convictions or things like that on their record, that can be problematic. Otherwise, generally, there's not a lot of other eligibility requirements, but they do need to be a legal adult.
Thank you.
Yeah, sure, absolutely. Okay, so when to apply? We've talked about 18 and how 18 is kind of that magical time when most people start to think about conservatorship. Ideally, we suggest that you start the process about 6 months before the 18th birthday because there is a process. There's paperwork that has to be compiled and put together. It has to be filed with the court. For those of you who may have had the unfortunate experience of dealing with courts before, you'll know that they don't work quickly. They're backlogged. They have calendars that sometimes can extend out months. And so usually about 6 months is kind of the sweet spot that's going to allow you to do what needs to be done and make sure that the conservatorship process is complete by the 18th birthday. We certainly can do it quicker if needed, but that's not ideal. And what you don't want to do is you don't want to wait too late where there's a lapse where the person's turned 18, and we can't get the conservatorship in place for several months, and then there could be emergencies that come up during that window, which we again could accommodate, but it just means more cost and expense to the family to do that. So ideally 6 months before the individual's turning 18 is when you really should start working on this. Now, we also have a number of people who don't conserve their family member at 18. And again, it could be because they just don't think about it. They don't realize that they need to. There's lots of different reasons why people don't. So it's not uncommon for us to work with families who have older family members in their 20s, 30s, 40s. I've even done it for individuals in their 60s. It just kind of depends when it becomes necessary. And sometimes, despite the fact that the parents can't continue to legally make decisions for the individual after 18, the reality is you manage to get by. If you've been working with the same medical professionals for years, they're still going to look to mom and dad, and the school district's still going to allow you to be involved in the IEP process. The regional center's not going to exclude you from the IPP process necessarily. So a lot of times people do manage to kind of get by for a while without needing the conservatorship. But ultimately, what we found is that at some point in time, something's going to come up where it becomes necessary. And it's usually better not to wait again until you're in a crisis, because then we have to try and do things quickly and we have to move things along faster with the court, which is problematic and can get expensive and costly. So it's always better to do your planning in advance and have the pieces in place so that they're there when you need them. Also, we can also apply for conservatorship early. So sometimes when I'm working with families, particularly if their family member is medically fragile, and there's concerns about not having even a day of lapse between the 18th birthday and the effectiveness of the conservatorship, we can actually file the conservatorship even a little earlier. So in those cases, we might recommend that they start working the process maybe instead of 6 months, 9 months ahead. If we file and the court sets the hearing before the 18th birthday, then what would happen is the order from the court would just say that the conservatorship becomes effective immediately on the 18th birthday. So you can certainly, in cases where there's a real need or fear, you can start the process earlier, but again, 6 months is usually sufficient. Okay, the legal process itself is really kind of compartmentalized into three basic segments. We have the process where you're working with the law firm or in some cases doing it yourself, but there's going to be a period of time where you're preparing and then filing the necessary paperwork. Again, because this is a court proceeding, it is very paperwork heavy. It's driven by paper, as is most things, unfortunately, in the law these days. Depending on the county where you're filing, there can be anywhere from 8 to 12 different documents that have to be prepared and filed with the court as part of this process. And that number varies, again, depending on how many conservators are in the mix as well. And the preparing and filing segment here is also the time when we're working with the medical professionals to get that capacity declaration completed that I mentioned earlier, and that document alone can often take several weeks to try and get completed and back to our office for filing. So it can take some time. We usually tell people that they should expect that from the initial meeting with our firm till when we actually have the paperwork ready for them to review and sign, you can estimate that's going to be anywhere from 4 to 6 weeks is kind of the ideal time frame. Sometimes, unfortunately, it takes a little longer depending on workflow. If we know we've got an emergency situation, we can try and speed that up. But generally, you're looking at about a 4 to 6 month 6 week window to get the paperwork together. Once all the paperwork is prepared, we then will go through a process where we review it with you, the client. You sign certain documents, they're returned back to us, and then we will file everything with the court. It's at that moment of filing with the court that the hearing date is set for the conservatorship hearing, and then the court process kind of kicks in and starts working. There's also, after that moment of filing, there's still paperwork that has to be done on our end, which includes serving all of the documents on the relevant parties. And we've got a slide we'll go through who those people are and that process in a moment. The second segment has to do with what the court has to do to prepare for the hearing. So fortunately, it gives you, the family, and it gives us, the attorneys, a little breathing space. So from the moment of filing and then us serving all of the paperwork to the point of the hearing, our work is kind of done, and we're just waiting to receive the work product from other people. Now, during this phase, the court is going to have other individuals that will be pulled in and will get involved and will be reviewing things and doing stuff. And so that's what we're waiting to receive before we actually all appear at the hearing. Then there is the hearing itself. And that is a process that, again, we're all going to need to be involved in, and I'm going to talk about a little bit more. And then there's this post-hearing phase, which is after the hearing, where hopefully the judge assigns your order, and then what happens thereafter, which is, again, very paperwork driven, and then ongoing, as Amy can attest to, because we were talking about this earlier. There is a process where the court is periodically going to ask you to file kind of updates with the court, and the court is going to review the status of the conservatorship on a somewhat regular basis. And so there's communications that will be going back and forth between yourselves, the lawyers, and the court in that regard on an ongoing basis. Now, preparing and filing the paperwork, as I noted, it's quite voluminous and does take a bit of time. We've already talked about the capacity declaration, so I'm not going to go through that more, but just I can't tell you enough times, this is the one document that can derail this process and can cause delays. So it's really important that you kind of be prepared to work with your attorney or with us if we're your attorneys to facilitate getting that completed. And again, I said 6 weeks. It says here on the slide 2 months, but just be prepared that there is going to be some time involved in putting the paperwork together. Your hearing date is going to be set, as I noted, when the paperwork is filed. And depending on the court, you can kind of assume that it's going to be anywhere from 2 to 4 months from the date of filing. Again, kind of dependent on the activity of the court and how backlogged they are. If you're in Alameda County, the court there is moving these a little bit quicker. We're looking at usually about 90 days, I think, right now, turnaround time from filing to hearing in Alameda. It's a little bit longer in Contra Costa. They seem to be a little bit more backlogged, but the courts do make conservatorships a priority. So, so it's rare that you're going to have anything that's going to go out more than, say, 120 days. Now, you also should be prepared that sometimes what happens, and unfortunately it happens more commonly than I think any of us would like or expect, is that the court can often continue that hearing. So you might initially get your hearing set at 90 days out from filing, but closer to the hearing, it can be that certain things haven't been completed on time. For instance, as I mentioned, the regional center has to file a report with the court. There's other things that are happening in the background. And if those things unfortunately have been delayed, then that can cause the court to continue the hearing further. Sometimes there can be technical or procedural glitches that happen. It happens to every law firm. Ours is no exception. We strive to be, excellent, but no one is perfect, and occasionally mistakes are made. So that, it's particularly with regards to the noticing that we'll talk about in a moment. If that's not done exactly perfectly, then sometimes the court will then make us redo things, and the hearings can get continued. So it's a good idea to think in your mind that the hearing is going to be 2 to 4 months out, but it can sometimes get extended beyond that. If that happens and there's some urgency to getting the conservatorship in place, the court is usually fairly willing to do temporary conservatorships and things like that if it's needed. But just be aware that there does need to be some flexibility with your dates here. I've mentioned notice a couple of times, and what I mean by that is when we file the paperwork with the court, and in between the date of filing and when the hearing occurs, there's a legal requirement that all of the, well, not all of, but most of the paperwork needs to be sent to various people. These are individuals who are involved with the conservatee, presumably, and people that might be interested and have some opinion as to whether or not the conservatorship is appropriate or should go forward. So they do need to be given notice, and the group of individuals involved is what the court calls all family members within the second degree. Basically, what that means is spouse or domestic partner of the conservatee, if there is one, children, if the conservatee is an older person and they have children, their children must be given notice. Parents, if the parents are still alive and aren't the petitioners themselves, are given notice. All siblings, and that includes half siblings. It does not include step siblings, but it does include half siblings and grandparents, again, to the extent that they're living. So it can be a fairly large group of people. There are no exceptions. So even if you have estranged family members, you're going to be required by the court to attempt to give notice to those individuals. Sometimes I will have divorced couples that we're working with, and that sometimes can be a little strange. There are sometimes family rifts where grandparents might be estranged, but in those cases, we still need to make every effort. And if we can't actually mail things to them successfully, the court makes us jump through a few hurdles to try and at least show that we've made our best efforts to give them notice. It's common for us to have to notice people outside the United States, individuals that don't necessarily, they live in rural communities where mail service is difficult. You still got to try. So just be prepared. You're going to have to, give up this information and work with your attorney to try and get this accomplished. Hopefully y'all have families that are close-knit and everybody likes each other and we don't have any problems. The conservatee has to be served in person. So one of the things that you would do, again, if you were working with our firm, is we would ask you to identify an individual who can personally serve the paperwork on the proposed conservatee. It, again, has to be someone over the age of 18, and it cannot be someone who is going to be one of the conservators. So it has to be kind of a neutral party. A lot of times families will use other family members who aren't part of the conservatorship directly to be the server. Sometimes it's close friends or neighbors. It just has to be, again, someone over the age of 18 that can hand the paperwork to the conservatee. Doesn't matter what the conservatee does with the paperwork once it's handed to them. They drop it on the floor and walk away. That's just fine. The person who served it just has to basically sign a document saying, I handed it to them on this date at this time, and that's all that's required. Okay, the court review and hearing process. So I've mentioned that the court is going to do certain things once we've filed the paperwork and your process has been commenced. So the first thing that happens is the court is going to appoint a court investigator. This is an employee of the court, and there's usually several in each county. They're responsible for going through the application and the paperwork that's being filed with the court. They are to perform a background check on each of the proposed conservators, and that background check is going to include running your criminal record to the extent there is one. They're going to look to see if there's one and then report any hits that come back to the court. They're also going to do a financial background check, a credit check, and that sort of thing. They'll run we have to have your driver's license number and your social security number, and there's lots of stuff that we have to give the court so they can do these background checks. They will also then personally interview the proposed conservatee. Sometimes they will do this at your home or the conservatee's home. They will do it sometimes at school. If the person is still in the school system, they will make arrangements to go out and visit them at the school site. And those are usually the two most common ways that they do it. The court investigator will then, after they've done all of this, will prepare a written report that gets submitted to the judge. It also is sent out to the attorneys involved, as well as yourselves as assuming you're the petitioners, the people who have submitted the application. So we all get to see what the court investigator has said before we show up at the hearing. An attorney will also be appointed to represent the proposed conservatee. Again, this is a legal proceeding where, in essence, you are in fact suing your family member for conservatorship, and so they're entitled to have legal representation as part of this process. The court will appoint an independent attorney. Depending on your county, that could be a member of the public defender's office. That is the method used in Alameda County. There are two gentlemen that work in the public defender's office for Alameda County that serve as the court-appointed attorneys in all of the conservatorship cases that we work on. So because it's just two of them, we're pretty familiar. They know us, we know them, and if there are any issues that come up as part of their representation, they're usually really good about reaching out to us, giving us a heads up, and then we usually can informally, hopefully, try and resolve whatever concerns or issues they may have. It's rare, I'll be honest with you. There's usually not a lot of controversy in most of our cases, so usually they're just kind of letting me know everything looks good and that they're not going to have an objection, which is what we want to hear. And they may or may not prepare a written report. Sometimes they do, and sometimes they don't. And if they don't prepare a written report in advance, that's usually a good sign. That usually means that they don't have much to report, and then they just verbally tell the court what their position is at the hearing. I mentioned that the public defender is used in Alameda County. What I didn't mention is that if you're in Contra Costa County, they use private attorneys for this purpose. The court will appoint someone who has put themselves out there as being available for this purpose, and most of them are going to be experienced, active probate attorneys like myself that understand this process and know the ins and outs of conservatorship. So for the most part, again, they're going to be very collegial. It's a small community, so again, most of the folks that get appointed are going to at least have some familiarity with our firm, and are, some familiarity with the individual attorneys that are with us. So anyway, the regional center is the third kind of person or entity that's involved here. The court will reach out to the regional center, provide the regional center with a copy of the petition that's been filed, and ask the regional center to submit a report to the court, letting the court know the regional center's position. Usually these reports are written by your case manager or the case manager supervisor. They usually consist of a 2 or 3 page document. The first page, usually a paragraph or two, is just kind of giving a general overview of the proposed conservatee from the regional center's perspective, talking about their functional ability, and some kind of just basic background information. And then they will go through each of the powers that are being requested through the petition. And you may recall I mentioned earlier the 7 powers, or the 7 areas of authority that the court can grant to you. So the regional center will go through each of those that's been requested and usually give a little blurb as to whether or not they recommend that the court grant it or deny it, and their rationale for why. And again, you will receive a copy of this report prior to the hearing, usually only a few days before the hearing, but before the hearing. And as part of that, if there are any recommendations for a denial, then sometimes we'll talk about it and decide whether it's something that we really want to kind of fight for or not, or whether the attorney thinks that the court will give any or much weight to it. Now, I will tell you that because the regional center does frequently recommend the marriage power and the social interaction and relationships power, that the court doesn't often give that a lot of weight, and frequently the court will grant those powers even over the regional center's adverse recommendation. So don't get too freaked out if you get a regional center report where they're recommending that those two powers be denied and they're ones that you think are appropriate. Odds are you're probably still going to get those powers, and unless there's really some sort of tangible reason why that's not appropriate. Okay, the hearing itself. The hearing itself, I'm going to just tell you right now, and Amy can probably confirm this, it's probably the least impressive legal proceeding that you'll ever experience. Probate court, as lots of people like to say, is not like real court. Of course, the probate judges would not like to hear me say that, but it's very collegial, it's very friendly, it's fairly informal. There's no putting your hand on a book and swearing to anyone that you're going to tell the truth, the whole truth, and nothing but the truth. There's people coming in and out of the courtroom. Again, it's a very informal sort of process. So I say all that so that you are not disappointed when you find out it's not like Law and Order. Further, because of the changes that have happened since COVID, we are no longer actually attending most hearings in person. Prior to COVID, we all used to get to go into the courthouse and we'd all show up and I'd be in my suit and you'd get to see me all dressed up. And we'd go in and the judge would be there in his or her robe, and it would be a little bit more like you see on TV. But these days we're attending most proceedings by Zoom. There is only one judge, and even now I think she's kind of gotten over it. There was one judge in Alameda County that for initial conservatorship appointments, she was still requiring that people show in person, but I haven't seen that happening lately. So I think even now she's using Zoom. So it's pretty low key. The conservatee will be required to appear at the hearing unless one of two things happens. You can ask your doctor or the person who's filling out the capacity declaration to check the box that it would be medically ill-advised for the conservatee to have to appear at the hearing. And that's one way of having the conservatee excused from having to make an appearance. Or when the conservatee is meeting with their court-appointed attorney, you can also request that that person waive their court appearance, and that's the second way. If neither of those things happen or work, then the conservatee will be expected to appear along with the proposed conservators at the hearing. Now, again, less of a concern now that we're doing it primarily by Zoom, but it used to be that when we had to appear in person, sometimes it was difficult for the person with a disability to make that trek to the courthouse or to be able to kind of sit patiently and quietly for sometimes up to 45 minutes or an hour or more while we were waiting in the courtroom. So again, less of a concern, but if it's something that you're worried about, be sure to talk to your attorney about it, and there is a way that you can usually get that person excused. The court will also expect that the proposed conservators will appear at the hearing. And again, this is less onerous now that we're doing things by Zoom, but it used to be in years gone by that everyone had to show up. There is a little lenience given. I mentioned if you've got, mom and dad and brother and sister, and, maybe siblings are off at college, or they're living on the East Coast, or they've got jobs where it's hard for them to get away. The court is usually not too concerned about that, but they will expect usually the parents to show up, or at least that kind of what we would consider the primary conservator, even though we don't really recognize that under the law. So just be prepared that you will need to participate in the hearing. Usually at the hearing, we're going to get, the court is going to grant it on the spot, and they will sign the order appointing the applicants as the conservators. That doesn't end the paperwork shuffle, however, with the court. The order itself is not what you use to indicate to the world that you're the conservator. That is through what's called letters of conservatorship. It's actually a document that's then issued by the clerk, and it's got one of those nice bumpy seals on it. It looks official. And that's the document that you ultimately will have to use when you're trying to show people that you are the conservator and have the legal authority that the court's granted you. And it usually takes a few days for our office to get that issued once we have the order in hand. So you won't usually be able to get it on the same day as the hearing, but you'll get it shortly thereafter. We also have to, after the hearing, serve a copy of the final order from the court on all of those same people that we served the petition on earlier. So there's kind of another round of mailing that has to happen. In addition, the court is going to set compliance hearings for you as the newly appointed conservators to do a couple of things. You're going to have to fill out and file what's called a general plan document. This is about 3 or 4 pages long, as I recall. And it's a document where you're basically giving the court much more specific information about the conservatee and their daily sorts of routines and the day program that they're in, and if they're still in school, what their school program is like, and medical information and medical history. And it's just a more comprehensive document that kind of informs the court as to the particulars of the person who's been conserved. And that's usually due within the first 6 months. The court, again, will set a date by which that has to be filed. And then annually thereafter, the court is going to ask you to complete and submit a status report. This is a shorter document. It's really intended just to update the court on any major changes that have happened with regards to the conservatee and or like changes of address if, the conservators have moved, or there's, it's just a way for the court to make sure that their file is kind of kept up to date. And again, there's going to be a date by which you're expected to file this. The court investigator similarly will review it. Then the court investigators on a regular basis have to go back out and kind of revisit the conservatee, and they do a report to the judge. If everybody does their job, then there's no need for you to ever reappear before the judge, but you do have to make sure you comply with the paperwork shuffle that's in place. And again, if you're working with an attorney, the attorney is usually available to help you with this if you choose to. Some people will also choose to just then monitor and handle all that paperwork themselves without their attorney, and that obviously saves you on legal expenses and costs. But that'll be up to you. And then I mentioned that periodically the court investigators are going to want to come back out and revisit the conservatee. They probably will interview you. Again, when they do this with my sister's conservatorship, what typically happens is the court investigator calls me. We have a short phone conversation, and they just kind of ask, has there been anything happening with Susan? How's her health been? Anything you want to report to me? And it's usually like a 5 or 10 minute phone call, not a big deal. And so that's kind of the process. It's very unusual for the court to require you to kind of reappear. That would really only ever occur if the court investigator uncovered something that was troubling or concerning. Sometimes that can involve, if there's been domestic issues within the household, or if someone's, been arrested and there's been some sort of a criminal thing that's popped up on a background check, you might be called upon to explain those sorts of things. But usually things at this point just kind of hum along. Okay, fees. We leave the fees till the end. So as indicated here, attorney's fees for conservatorship, if you're working with our firm, my experience is from start to finish, you're kind of looking roughly at about $4,000 to $5,000 in attorney's fees. And again, that's pretty much going to cover everything through getting your letters of conservatorship issued to you. Additionally, it's not required that you have an attorney, as I mentioned earlier, but I'll be honest, many families attempt it on their own and then find that it's more challenging than they expected and end up hiring an attorney partway through the process if they haven't hired one at the get-go. As I mentioned, there's a lot of paperwork. You have to fill out judicial counsel forms that have been created by the court. They're not exactly user-friendly. And you also have to handle all of that notification and filing the proofs of the notice to all those individuals, and it can be a bit of a chore. So, while you don't have to have an attorney, many people discover that it's very helpful and necessary. There are some self-help services available, so if you do want to try and do it on your own, go for it. The Alameda County Court has a workshop that they offer on a periodic. I think they usually do it about once a month, or maybe it's once every couple months, but they do have a calendar available on their website, which we've given you the link for there. And you can certainly take advantage of those workshops where they'll help you kind of fill out some of the forms and help you with some of the, how to do these sorts of things. And then in Contra Costa County, there is a probate facilitator that works for the court, and we've given you the email address for that office, as well as a number where you can leave them a voicemail, and then someone from the court can call you back. And again, they're going to provide you with forms, and they'll help you with basic questions about kind of how to fill things out and stuff like that. So take advantage of those, and I believe both of those are free. The bar associations, we don't have the information on the slide here, but I know, for example, Contra Costa County Bar Association also offers some Ask a Lawyer type sessions where they occasionally have them focusing on conservatorship. So that would be another resource that you could look into, would be either the Contra Costa or Alameda County Bar Associations. Court fees will generally be waived. There are a number of fees that the court can assess, but if the person who is being conserved is of limited income or assets, they generally will agree to waive those fees. Those fees include the filing fee for the petition itself, which is $435. They will also waive the cost of the court investigator, which generally, I believe, in Alameda County is assessed at about $800 if they require you pay it. But again, in probably 95% of our cases, we find that those fees are well, they don't waive them, they defer them, but it's kind of the same thing. And then you also will not be responsible for paying for the court-appointed attorney, regardless of whether you're in Alameda or Contra Costa County. The courts will pick up the cost for those attorneys as well. So really the only hard fees that you're typically paying are the fees for your attorney, for our firm, or for another firm that you might be working with. The exception to that waiver would be if the conservatee has a funded special needs trust. Now, this doesn't mean that if you've kind of put together a special needs trust for inheritance purposes and it's just sitting there with either no money or very little money, that's not going to be a problem. But if your family member does have a larger funded special needs trust, that does need to be disclosed to the court. And then in those circumstances, they probably will not waive the fees, and they'll require that the trust cover those costs. And that will bring me to the formal end of my presentation, but I am absolutely happy to stick around. I realize it's 5 minutes after 8. I went over by 5 minutes and I didn't leave much time for questions, Amy, but I'm happy to stick around as long as people want to ask me questions.
Okay, I'll just throw out a couple that I thought.
Okay,
so what happens, or what's your suggestion if the physician, the GP physician, does not want to fill out the capacity declaration?
Yeah, that's a hard one. So sometimes what we'll do is we'll explore if there's another medical professional that might be able to do it rather than the GP. Some of our clients might be working with a general physician, but they might also have a psychiatrist they're working with, or a psychologist, or a counselor. So any of those individuals would be able to do it. Sometimes they might have specialist doctors. So if the general doctor isn't comfortable, maybe one of their specialists might be willing to. It can be done by basically anyone who is licensed in the state of California and has seen the individual within the last 12 months. So if none of that works, we have had clients who have gone out and sought just a private assessment. You don't have to go to the degree of having like a full-blown psych evaluation done, but you may be able to hire an individual just for the purposes of doing a basic assessment and then filling out the form.
Okay, and then what if the conservator and the conservatee live in different counties? Where is it filed?
That's a great question. So the venue, as we call it in the legal world, of the proceedings is always going to lie where the conservatee lives. So if the conservatee is living in Alameda County and the proposed conservator lives in Contra Costa, then it's going to be, the proceedings will be held in Alameda County. There is one thing I will make you aware of, because this has come up as a problem in a couple of our cases. If the conservatee and the conservators live in different school districts, and the person is still in school, the conservatee is still in school, the school district is determined by where the conservator lies, not the conservatee. So it's just something to keep in mind, that if you have a school-age person that's, under 22 that's still in special ed, and they're maybe in school, say in, I'm just going to pick on the Pleasanton School District, and the conservators live in, say, Berkeley, then the Berkeley School District, by virtue of the conservatorship, would become the responsible school district. And that, in a couple of cases, has been problematic, where it's put people's education system, schooling placements in upheaval. But we managed to work through them, but it's something to be aware of. You don't want to get caught in that trap.
Right. Is it too young to start the process when your child is only 16 or 17?
16 is definitely too soon. The court would politely say, yeah, we're not going to deal with this. Come back in a year or so. But you could probably get away with filing something shortly after the I mean, the court wouldn't like it if you file it like right as they turn 17, because it's still a whole year away. But you could probably file it, 6 months, 8 months ahead, and the court would probably be okay with it.
I think those are the ends of our big questions.
Okay.
I'll just make a comment here that you referred to me a few times, because I've gone through the process, actually twice, because our daughter was not 18 yet when we first set up the conservatorship. So we had to do it again when she became 18. But one really unusual thing happens all the time, is that even though our son is conserved, when I talk to Medi-Cal or Medicaid or healthcare agencies, I tell them that our son is conserved, and they still require a form to be filled out, which gives the right of representation, which makes no sense to me because legally our son doesn't have the powers to sign over the process to make me his legal representative, but they insist on it.
Yes, I will echo that. With my sister, again, I'm her conservator. It's in her medical charts at Kaiser that I am her conservator along with our father. And still, virtually every time I go to a doctor's appointment with her, they open up the computer and immediately ask me no, they don't even ask who her medical decision maker is. They want to know who her DPA is, which is her agent under a power of attorney. And I've given up trying to explain it to them. I just say I am, and they go on with life, and that's fine. So you'll kind of learn that there's the legal realities of all of this, and then there's the practical realities, and they're not always consistent.
Okay. That's it. I think it's a wrap.
All right. Well, thanks everyone. I hope it was helpful, and I'm sure we'll see you all around at another webinar. Thanks, Amy.
You're welcome. Thank you, everybody. If you have any questions, feel free to send an email to info@Dale Law Firm or to me directly, Amy@DaleLawFirm.com.
Great.
Happy to help.
Thanks.